Hello and welcome to the second season of my podcast, Think Like a Lawyer. My name is Angela Sielu. This week we'll dig deep into the concept of contracting with a minor. We'll look at what capacity means in contract law and what age is required for a minor to enter into a contract. What are the minor's obligations and liabilities? Stay tuned and let's get started. Capacity is the ability to create or enter into a legal relationship under the same conditions that a reasonable person would have the ability to do so. More specifically, capacity is the satisfaction of a legal requirement such as legal age or soundness of mind that establishes one's ability to sue or be sued or to enter into a binding contract. Now, due to public policy, several groups of people are exempt from contractual liabilities. These are children, individuals with mental impairment, or drunk people. This episode will focus on minors. So, who is a minor? A minor under common law is someone under the age of 21. Article 28 of the 1992 Constitution says a child is a person under the age of 18. Child is a person under the age of 18 under the Interpretation Act of 2009. Writers like Dorona Hammond expressed skepticism about the applicability of these legislations and rules to the age for contractual liability and argue that the common law age of 21 should take precedence. That is, minors should be considered everyone under the age of 21. At common law, contracts made by a minor are not legally enforceable against the minor, meaning that contracts made by a minor are not, according to common law, legally binding against the minor. These agreements, however, are enforceable against the adults who contracts with the minor. This is the general rule. However, there are exceptions to this rule. And these are the exceptions are agreements for necessaries or contracts for necessaries, beneficial service agreements, and voidable agreements. So we'll take a look at each of these exceptions one after the other. What do we mean by necessaries or contracts for necessaries? The phrase necessaries or the word necessaries often refers to things that a person must have in order to survive, such as food, clothing, shelter, education, medical care. Now, despite this, case law and the legislation itself have given the term a very clear two-part definition. Case law has given some definition to the word necessaries. And then the first part is they are goods or services, or the goods or services must be necessary in light of the minor's station in life. Necessaries should be goods or services that must be necessary in the light of the minor's station in life. The items must meet the minor's actual needs at the time the contract is established. So if the minor is contracting with an adult for the services of things that are considered by law, by case law, as necessaries, then they are binding on the minor. For extra items don't affect the minor. This reflects a legal understanding that the definition of necessaries is subject to change depending on the circumstances and the minor involved. For example, minor A might need an excellent education, whilst minor B might only need food. So necessaries depends on the minor's station in life, as I explained earlier. According to Section 2.3 of Ghana's Sale of Goods Act 1962, Act 137, the definition of necessaries is goods that are suitable for the person to whom they are delivered and to his actual requirements at the time of delivery. In Shapi v. Cooper, it was decided that a contract allowing a minor to buy a coffin was necessary because the minor had to bury her husband. is suited that minor's current stage of development or current station in life. In the case of Nash and Iman, a claim for the cost of fancy waistcoats was rejected because it was determined that the minor already possessed sufficient number. Therefore, the recently obtained products did not meet the genuine needs of the minor. It should be noted that even if a contract is determined to be one for necessaries, it may not be upheld if it is shown to be harmful to the interest of the minor or simply too onerous or harsh. In Fawcett and Smithhurst, it was determined that a minor who hired a car to transport bags was in a contract for necessaries. However, the contract was nullified by provisions requiring the minor to pay for any damage to the car, regardless of whether it was their fault. Contracts for necessaries will therefore be typically binding on the minor only to the extent that the provisions therein are reasonable. The court may therefore direct the payment of a reasonable amount instead of the contract amount. We move to beneficial contracts of service. Since minors can work and will eventually become adults, they must learn and develop skills that will help them. Invariably, entering into contracts for training, instruction, and apprenticeship, etc., would lead to the acquisition of these talents. If the conditions of such contracts are generally in the minor's best interest, the minor is bound by them. These agreements are legally binding for the minor if they are generally in their best interest. But there are some exceptions to this rule. When a minor signs an apprenticeship contract, the courts will not uphold the agreement if the terms are deemed severe by the child. In the De Francisco and Barnum case from 1890, the court determined that the contract's provisions were too strict for the minor and were consequently null and void. So if the contract will be to the detriment of the child, the court will not uphold it, and the contract will not be binding on the minor. Trading agreements are therefore unenforceable, even if they are advantageous to the children or minors. Look at Cohen and the Neard case. However, take note that the court will order a return of the property if it is still in the minor's control in accordance with the equitable restitution principle. So we move to voidable contracts. It indicates that if one party decides to do so, the contract may be deemed void. The general rule of minors is that voidable contracts are binding on them until they reject or cancel them while they are minors or within a reasonable period of time after becoming adults. It should be noted that terminating a voidable contract only releases the minor from responsibilities that will develop in the future, not from obligations that have already existed before termination. For instance, a minor who rents an apartment breaks the lease. He has to cover the accumulated rent. The general rule is that when a minor enters into a contract by which he acquires an interest in a permanent subject matter with recurring obligations attached to it, he is bound by the obligations so long as he retains the contract. It is quite typical for the minor to acquire some interest in the subject matter with recurring liabilities. If the minor does not take action or release himself from the obligation by cancelling the contract while he is still a minor or soon after becoming an adult, he will be bound by it. Next thing we'll discuss is the minor's liability in loan agreement. A loan of money to a minor is not recoverable under common law. As equity, only that portion of the loan that was used to purchase necessaries may be recovered. In light of this, the Student Loan Scheme Law 1992 PNDC Law 276 drafted a clause that presumes all loan beneficiaries to be of legal age and capacity. Therefore, this one do not fall under the exception where minors are not obligated to meet their liabilities under the loan agreement. We have minors' liability in tort. Minors are liable for their crimes. The minor is not liable, nonetheless, if the tort results from a contract that is not enforceable against them. This is done to stop claimants from indirectly enforcing contracts that would not otherwise be enforceable. For instance, torts committed in the context of trading contracts or onerous contracts for necessaries are not upheld. In Fawcett and Smithhurst, in which a young person damaged a car by exceeding the speed limit, the contract itself was overly harsh, making the tort unenforceable. It goes without saying that the tort has to be committed while carrying out an action that was planned out in the contract. Now, there are some situations where you will not know that you are actually contracting with a minor because the minor will intentionally misrepresent his age. What are the consequences in the situation where an adult finds himself contracting with a person who purports to be an adult? The law says that where a minor tricks an adult into a contract that is not ordinarily binding on them, the minor cannot be sued to refund the money. I take it again. Where a minor tricks an adult into a contract that is ordinarily binding on them, the minor cannot be sued to refund the money. An action in fraudulent misrepresentation will not also succeed since it is linked with the contract. In Leslie Limited and Shell, money lenders who were induced to lend £400 to a minor after he misrepresented his age failed to retrieve the amount. Loans are generally irrecoverable unless used for necessaries. So this is how we draw the curtain down on today's episode on the topic capacity to contract with minor.